Let me mention. May it please your lordship,
Yes.
I beg to mention item number 26. We are for the petitioner, your lordship. The conducting counsel is indisposed, your lordship. The matter can kindly come up after 2 weeks, your lordship.
Who's the other side?
And
26. After?
after 2 weeks, your lordship.
After 2 weeks. That is to- Yes.
Biblio applies.
Please, Your Lordship. I beg to mention item number 19. These are those cantonment matters.
No solution till now.
Your Lordship, the latest development that we've come across through the newspapers that a committee has been formed, Your Lordship, by the state government. Your Lordship may kindly peruse
Is it
the second page.
Was it a newspaper?
Your Lordship, the second page, Lordship.
15 March 2025.
Yes. Yes. So what is to be done?
We're praying for time, Your Lordship, until this is whatever the outcome of this.
The landed council appearing with the parties submit that a panel has been formed to deal with the issue of merger plans. This is the issue of merger of cantonment areas of Shillong Cantonment Board with the areas of the Shillong Municipal Board. Is it correct? Merger of areas of the Shillong Cantonment Board with
The
the areas
Shillong
of the
Municipal.
What is it? And the decision is still awaited. The parties therefore pray for adjournment of the matter to await the outcome of the decision of the panel. Yes, sir. What is it? Last week the council therefore pray for adjournment of the. Okay. Okay. Just say prayer aloud. List after. 4 weeks. 6 weeks.
6 weeks.
List. Yes, prayed for list after 6 weeks.
So it's item number 19 and 20 are similar. I'm appearing in 20.
Yes, same order then.
Lordship. All right. This Lordship, my
Yes.
Lord, we pray for adjournment. Hearing number 18.
Item number 18. my lord.
Joint prayer, my Lord.
Item 18.
18, my Lord.
Yes.
My lord, here we have just been instructed to appear for the district council respondents 1, 2, 3, and 6. My lord.
Yes.
So paid for 3 weeks' time.
Let's see. Mr. Sangma Learned Council appearing for the respondent number
1, 2, 3, and 6.
1, 2, 3, and 6 submits that he has been recently engaged by the said respondent in this case and prays for grant of some time to go through the matter.
My lord.
The London Senior Counsel appearing for the petitioner has no objection. Prayer allowed, list after 3 weeks.
Oh, Lordship.
Please, Lordship. Lordship, I beg to make mention item 17, Lordship.
Item 17.
Lordship.
Yes.
I'm praying for 2 weeks' time.
2015 matter, isn't it?
State is just a formal party in this case.
Who is the contesting party then?
This
State Lordship. State Lordship. It's a DC of.
this is
State says it's a formal party.
No, Lordship.
is a private party that before it was represented by I think S Center.
No, Lordship. The private parties in this matter has been withdrawn, Lordship. He has been withdrawn himself, Lordship. Now the state is the main party, Lordship.
The private party has been withdrawn.
Yes,
This
Lord.
private party is no more a party in this case
No,
now.
Lordship.
The party has withdrawn himself, or you have filed an application for striking of.
No, the counsel for the appearing for the private parties, he has withdrawn himself.
The council has withdrawn.
Yes.
The party has not withdrawn. Anyway, just say respect for the Land Council for the petition and not objected to by the Land. Causing appearing for the state respondents. This is matter after 2 weeks. Yes, sir.
Highly obliged, Your Lordship.
Lordship, I'm praying for similar prayer for item 24 on behalf of other time legal counsel. He's not available, Lordship, today, Lordship.
24. 24.
Yes, Lordship.
Any interim order in this matter?
No, Lordship.
You are for the state.
Yes, I'm from the state.
This on the prayer made on behalf of Ms. Ardhita, Learned Legal Aid Council. This is matter after 2 weeks.
Your Lordship, I beg to mention item number 21. Your Lordship.
Item 21. Item 21.
Yes.
Your Lordship, kindly let this matter come after 2
Lordship,
weeks.
this matter has been heard at length, Lordship. Only one issue remains in this matter, Lord. They have been asking time again and again. Only one issue remains here.
It was very inappropriate in order to say you argue the matter at some length and
At
then
some length it
suddenly-
was argued, and one question came from your Lordship, whether the extension can be done retrospectively. So,
passport, that passport.
yes, yes, Lordship. It was done after 1 year from its expiry.
The court has again forgotten everything, Mr.
And
Karma.
we have taken time on that issue only.
Have you submitted any written notes of argument? No.
No, no,
Any of the parties? No.
no.
Why don't you do it? Probably, I think Mr. Gurung is appearing.
Yes,
The last
he's
occasion,
okay.
he said that he will prepare some written notes, and then, if not a lengthy argument, just only to give the.
They are asking
notes.
time to.
Because if the matter is adjourned like this, the court would not remember it, and it is not possible for the court to note down each and everything.
Yes, they are asking
miss
time
out
to find a judgment, Lordship, on that issue, whether it can be done
Oh, and then
retrospectively.
in addition to that, he said he will file a written note.
Let him file, Lordship, then
Anyway,
we'll
just
hear it finally.
it is not proper. You see, like we will grant you time to this time, but then not. Just say the request of the petitioners list of 2 weeks.
Obliged, Lordship.
Highly obliged.
Your Lordship. This is item number 28, Your Lordship. Lordship, your last occasion, Your Lordship has, because there's a settlement, deed, but Your Lordship said that it should be registered. Has asked me to see.
Not registered.
It should be registered. Your Lordship.
It has to be on an every stamp paper.
Stamp paper.
The agreement you execute on a stamp paper.
Yes, sir.
All kind of agreement is not required to be registered by law.
Okay,
You will go for registration with whatever is needed to be registered. Otherwise, no.
stamp paper, Lordship. So that's why Your Lordship has asked me to seek instruction. I want to withdraw with liberty to file flesh.
This item
28.
Yes, just say. Mr. B. Karim, Learned Counsel, the favor the petitioner on instruction submits that the petitioner would not like to pursue this matter and prays for Warrior of the same with liberty to file fresh paragraph. The same view of the submission made. This petition stand dismissed on withdrawal with liberty as prayed for. Yes.
Item number 1. My Lordship. May I please, Your Lordship?
Yes.
I beg to mention item number 23.
Oh, else the matter has been called away.
Lordship, she's for
Again,
private
you were
response.
there. There should be somebody to guide her.
Yes, yes.
23.
Yes, item
23, Lord.
23.
on behalf of
She's for
Sir,
private
SP.
respondent. SS sake.
yes.
I
Oh,
put a
he's out of
petition.
station.
She's
He's
out of station.
We pray for 2 weeks' time, my Lordship.
Lordship, no objection.
Yes, sir. Let's pray for on behalf of Mr. S. Sheikh Learned Council appearing for the respondent number so and so. This is matter after 2 weeks. Yes.
Much press, Lordship.
Item number 1.
Yes, Mr.
Yes, Your Lordship, the leading counsel, this count is on leg, so if this matter may be taken up at the end of the board, Your Lordship.
At the end of the board.
Yes, Your Lordship.
At the end of the board.
At the end of this, let it
End of the board.
I'll oblige, Your Lordship.
Item number 2.
Wait, please, Your Lordship. Your Lordship, items number 3 to 16 are connected. Your Lordship, on the last date, Union had produced a letter, Your Lordship, seeking instructions from the state. Your Lordship, I'm praying for some time. Your Lordship. The instructions are in the midst of preparation, Your Lordship.
Instruction. Additional provision.
Yes. MS getting out of here. G preparing for the state. The respondents has prayed for grant of some more time for obtaining instruction.
Yes, Your Lordship.
Stop the prayer has not the prayer is not opposed by the Learned Council appearing for the petitioners. Prayer allowed, next after
2 weeks, Your Lordship.
2 weeks. Yes.
Obliged, Your Lordship.
Hearing item number 22.
yakin. Itu dan nanti ya. Kira lah. Item 22, Lordship, Mr. A.H. Kharwannang is appearing. He is unlike in this court number 3.
So what is to be done?
Let it be after 1 week. That's it.
Yes, Mr. Nangpur.
After 1 week.
Let it come
Or
after
any
2
day.
weeks, Lord. It come after 2 weeks.
Just pray for what is. This is matter of weeks.
2.
Item number 25.
Yes, Dr. Majida.
The senior is there.
Oh, yes. Yes, sir. Yes, Mr.
27 Lordship, in this matter, Mr. K. Khan is appearing, leading us in this matter. He is unlike Lordship.
So what is to be done?
If it can be taken up after some times.
Well, we can argue in the meantime. We can note down.
Will be proper again. He will come and he would say this argument. If it is made before the council, it is better. You are not audible. You are not audible, Mr.
Please unmute. Just still not unmute. Please unmute.
Please unmute. Think probably you. That is a problem. We'll have it on some other day. Dr. Mojiga, you have to explain.
Madam. Oh, he finished Lordship in that court.
He's finished, but then now we are having problem here.
Then 7.
Well, after the next matter, in the meantime, we'll fix it. Well,
We have another matter for end of the board. The problem is that senior counsel is not audible. So
we will connect it. Well, 1 minute. Well. This is called senior counsel is not audible.
we cannot go like this.
Next week.
Yes. It appears that there is some connectivity disturbance with the London Senior Counsel appear for the petitioner. Let this matter be disturbed after a week.
After
Any interim order here?
interim order.
It was made it was made returnable until further orders. I think so. As per the last
Until
order,
further order.
until further orders.
It's till the next date only.
Next day.
Yes. Okay. Interim order passed already. Continue.
Continue.
Continue. Till then.
Second call. Item number 1.
It's difficult. You inform, please, you inform him somehow. You inform the senior counsel, he might not be. Yes, okay. Yes.
Lordship, item number 1, in the last date we got stuck up. My learned friend relied on a judgment regarding provision of law, and I also relied on a judgment. There were 2 judgments I
Just
separated.
you will refresh the mind of the court.
Lordship, the only issue was that he was challenging the maintainability on section 108 of the CPC. Lordship said, kindly bring a specific judgment on that. So we are today only on that issue.
Okay, that is on the question of maintainability.
Maintainability.
This is a revision.
This is a revision. And Lordship asked 2 very important questions against Additional Deputy Commissioner's order.
According to Mr. Dondi, that this order is appealable.
Appealable. But he was relying on a judgment, which stems from a different provision of law. So court, it fell from the court that kindly give the provision that you're relying, kindly give a specific provision for the simple reason that against deputy commissioners.
What is the factual ground of the case?
Factual, Lordship, interim order was granted in my favor.
You are the plaintiff.
I am the plaintiff. Interim order was granted in my favor.
What are 39 rule 1 and 2?
The 39 Lordship was heard after hearing the parties, interim order was passed, and they challenged the interim order. So that interim order was vacated.
The challenge in appeal.
Appeal. So on a fact,
they did not appear before the trial court.
They appeared.
They filed their application seeking vacation.
Seeking vacation, and appellate court on Lordship on a very technical, factual ground.
Whatever, just give us the facts. We'll just give us. You file a suit.
I went to the trial.
Application for
stay. Interim
stay. It was
stay.
granted to you.
They are granted to me.
They appear. File their objection.
They file an objection. They appeared. They file an objection. It was made absolute, and then they challenge the interim order before the appellate court. So appellate court set aside. Now the situation is against appellate court's order. Against appellate court order, what will be the forum for a injunction order?
The question is whether second appeal would lie.
Lordship it is.
And if it lies, then
second appeal lies, what happens? Or whether revision, whether second appeal or appeal. Then we relied on each other, relied on a different judgment. I am come under 2 to 7.
2 to 7.
2 to 7.
Why not 115?
Lordship, 115 will not lie because the list was disposed of. And then Lordship, there is a situation.
But then it is with regard to some internal quality.
So Lordship, because that is again the larger issues is this, Lordship. There are since PepsiCo.
We will just see Mr. Nandi. We will hear Mr. Nandi because since he is challenging his maintainability.
So only thing today is this: he has to produce a judgment on their specific whether second appeal will lie or not. We only on to that.
Let us see.
Yes, my lord.
Yes.
On the last occasion, I had submitted that there is no provision for CRP. The 2 to 7 cannot be invoked. So far as this present case is concerned, they have come up and they have relied on.
According to you, what should be the correct?
There is, my lord, there are 2 things. On the last date, I had mentioned that 108 of CPC itself provides the procedure. And that procedure itself is that 104 1I itself is the provision. And there are also authorities, I rely on this, that Himachal Pradesh High Court has, on the last occasion I had referred the Supreme Court, the Lordship of Apex Court has held that there is no scope for this CRP under 2 to 7.
Let us see 104. What is section 104?
104 is, an appeal shall lie from the following orders and save otherwise expressly provided in the body of this code or by any law for the time being in force and no other orders. Here I, any order made under rules from which an appeal is expressly allowed by rules.
What does it mean?
This means that if they are aggrieved, they can come up under this 104. But they have not come. They have
does it cover the second appeal?
My lord, second appeal against order is possible.
That is where we need.
Yes. Second appeal against order is possible. They are not coming on that. They have come on CRP. And if the Lordship kindly peruse their prayer, there is no schedule. Because why the learned lower appellate court is interpreted?
We will come to that thing. Do not shift. Do not jump to other thing. First, you just see.
Second appeal, yes.
This court is not very equipped with the provisions of intricacies of CPC and all. So you just place. If you are raising certain issue, if you say this order is appealable, then
Yes.
just place it with us. Once you establish it, definitely where there is no question.
My lord,
See, 227, as this court understands, can only be invoked when there is a grave error
yes, that
of
is
law, or say like the trial court travels beyond boundaries.
yes.
Only,
But here,
not just merely because there is an ordinary error of law. 227 will not lie.
my lord,
Definitely, that is one thing which is there in your favor. That is one aspect.
my lord, this authority, I rely on this Baburam and others versus Sri Bhakatram. This is of 2nd November 2023. The High Court of
Have you
Himachal
given a
Pradesh.
list of
Yes,
cases?
my lord.
Have you submitted it here?
Today I am placing.
No, you have to, before the hearing starts, you have to give it so that a book comes.
I have given this extra copy for the lordship.
And what about the other side?
I have referred that this is the judgment.
This is not reported anywhere. Where is the citation?
This is the citations, my lord.
What is citation? This is the
This-
citation means?
Citations is
It is reported where?
I got it in the online when I have.
You just give us whether it is reported or not. Any concurrent
It is-
citation,
it is-
anything.
It is definitely reported, my lord.
Where it is reported, just tell us.
I have taken the copy from.
Mr. Nandi, you should verify that. See, these are basic things. You are a senior practitioner. At least you know those things. So that will help us, help the other side, everybody. If you give citations, otherwise it will be simple wastage of time. What is the relevant part?
Relevant part is, my lord, this para number 9, if your lordship kindly peruse. Same, in that case also the same and similar thing came up.
Wait,
Before
para
asserting the
number?
correctness of the genuineness of the
Just a minute. Wait for the code. Do not be too
Fine.
fast. Para 9. At what page?
second page number, para number 9,
Page?
line number.
No,
it is
page. Para 9.
Page
is
number 5.
Yes.
Page number 5.
It
And
starts with?
it starts with this quote from the top, the second line, middle, this quote.
The
at first-
paragraph starts with before.
Yes,
What is this RT with this before?
it is
This
most.
is the problem. You see, if you are holding a copy.
No, he has not given me the copy.
The problem is that you see, like if these are print out from some unknown sites, then thing comes in such a way, and we do not know whether it is correct or not. See paragraph 9, how it starts. It starts with RT, then before.
This RT most probably it is, there is some.
We have to apply our guesswork. That is the problem. See, Mr. Nandi, it has happened that certain judgment downloaded from some unknown site, and later on we found that this is inherently wrong. In the original judgment, it was not there. So at least if you basically make your submission basing on some judgment downloaded online, please give us the citations so then we can verify.
Then, my lord, where it is reported, that I'll have to search for because there is no alternative.
No, you can find it out. Why?
Because where it
once
is,
you know the party's name, you can make out whether it is reported in
because
journal or not.
I'll have to make a search that where it is
That
reported.
is a matter of 2 minutes work. Tell your junior to do that. They are very expert nowadays with this new system, so they will do it, find it out very fast.
Where it is reported. And moreover, my lord, one more thing is that after the CPC has been fully applied, in the state of Meghalaya by the notification. Thereafter, this present suit has been instituted. CPC has been applied by notification number
Which
20
effect from which date?
from 20th September 2022.
Yes, and this
And this suit is instituted on
Hmm.
12/10/2022.
Yes, then under which provision of CPC the second appeal lies in an injunction matter?
So far as it is section 100.
Section
The-
100 speaks about decree.
It speaks about that decree. Now here
Speaks about appellate decree.
appellate decree. And so far as this present, it is 104, as I have relied on. That 104, section 104 itself gives the provisions that if anybody is aggrieved by any order, the as provided under the rules, the appeal lies. In view of that, they can come up.
Does it not refer to first appeal?
No, my lord. First appeal is on the last occasion, my learned friend has hammered on the point of the rules for administration of justice in the Garo Hills. But that does not apply here. So, as the suit has been instituted after the implementation of the notification. Yes.
So rules definitely is something the question,
Yes.
the application of rules.
So, the present appeal, that present CRP that they have filed, it is the burden on the respondent, not on the respondent but on the petitioner side, that how they can invoke the provisions of.
The question, the things are a bit different here because you are challenging the maintainability.
Exactly.
Isn't it?
Exactly.
Now, if you challenge the maintainability, us is or you to show how it is not maintainable.
My lord, I have on the last occasion, I have given that Honorable Apex Court Authority, which specifically provides that this CRP under 227 is simply not maintainable.
The law which you are citing now,
Yes, my lord.
that Himachal judgment, just read the part which you want to read it.
That page number 5.
Yes,
From
read.
the top.
Yes, read it.
The second line, this
Yes.
court at first instance deems it fit to deal with specific question raised with regard to the maintainability of the petition filed under Article 227 of the Constitution of India, laying therein challenge to the finding rendered by the learned district judge in appeal filed against the order passed by the learned trial court in an application under Order 39 Rule 1 and 2 CPC. At this juncture, it would be apt to take note of the judgment passed by the Honorable Apex Court in case titled Garment Craft versus Prakash Chand Goel, 2022, Volume 4, SCC 181, wherein it has been specifically held that while exercising supervisory jurisdiction under Article 227 of the Constitution of India, the High Court does not act as a court of first appeal to reappreciate, reweigh the evidence or facts upon which the determination under challenge is based. It has been further held in the appellate judgment that the supervisory jurisdiction is not to correct every error of fact or even legal flaw when the final finding is justified or can be supported. Power under Article 227 of the Constitution of India is to be exercised where there is no evidence at all to justify.
That is okay. So that doesn't say that it is not maintainable.
Yes, it is not maintainable.
Doesn't say it is not maintainable. It says it is maintainable, but then dependent on certain situation. Now, whether this situation arises or not, to verify that you have to go into merit.
If Lordship decides.
Now, say supposing, you see two things. If you are harping on the issue of the scope and ambit of 227, that is one aspect. But then it doesn't say that it is not maintainable at all. Okay, it says it is maintainable only on certain situations. It cannot be an alternative of, you see, like any other provisions. Like it cannot act like a first appellate court. That is what is provided here.
First, yes.
Now,
cannot.
the situation which makes this Article 227 maintainable or not is dependent on the facts or the merits of the case. So it cannot be something like that, it will be outrightly rejected because not maintainable. Now the second thing is that if you say about the maintainability of appeal. Now if you say that the order which is under challenge here is otherwise appealable, then definitely we may say that this 227 application is not maintainable. But then show us that this is the order passed is appealable.
My lord, as I have respectfully, it is my respectful submission before the lordship is that section 104 itself provides.
It elaborate you see, like the filing of an appeal under any rules and filing an appeal against the appellate orders are two different aspects. See, like say supposing if it is comes to a question of filing appeal against the order court passed by a trial court, that is one situation. But then if it comes to filing of an appeal against the order of the appellate authority, then it stands some slightly different footing.
My lord, so far as this authority of Himachal Pradesh High Court, there also appears the same and similar questions. There is also an appeal before the district judge, and the district judge had held in respect of this injunction matter, and the same appeal, the CRP was filed, and it is there in this Himachal Pradesh judgment. There are two things has been decided. That one is that CRP is not maintainable. On the other hand, it is also decided that the order against which this CRP has been filed, that it doesn't suffer from any infirmities in this judgment.
See what it says. If you see the part which you have read out, it's a power under Article 227 of the Constitution of India is to be exercised where there is no evidence at all to justify, or the finding is so perverse that no reasonable person can possibly come to such a conclusion arrived at by the courts below. Now, to determine that, we have to enter into the merits of the case.
Then let the merit be heard.
So that is why. So that is
if the lordship is,
you say about maintainability.
Yes.
So we thought if you question of maintainability, we will not even admit it for hearing. Now, once you say that let it be hard on merits, then we'll admit it for hearing and we'll go for final hearing.
Because so far as this judgment is concerned and the honorable apex court that I have relied on.
No, but then you have not clarified that part about the maintainability of second appeal in injunction matter.
My lord, as it is my respectful submission before this.
See, you have to cite some authority.
I have cited the two authorities of one apex court and that of the
You are citing authority on 227.
Yes.
But then where it is said this order is appealable?
In that aspect, I relied on this section, the CPC.
You are coming back to the same thing. There is no elaboration of things.
And if the lordship decides that that the merit is to be heard,
there is no question of deciding. This is basing on the authority which you have given us.
Yes.
We are going by what you are showing us.
Yes. On this, here it says
the Himachal decision which you have given us, that we have to determine whether that order is perverse or not.
Yes.
It is not
on that point. On the point of perversity.
The maintainable of 227, so far as 227, if we find that there is no perversity and there is mere illegality, then we will reject this application. But then this has to be done after entertaining the petition on merit.
If the lordship decides
we cannot shut him down at the maintainable state saying that 227 cannot be maintained. Cannot be maintained means the very filing is incorrect in law. We cannot say that at this stage, can we? Yes, we can say, but then you have this You have referred to 104I
Yes.
CPC. Now it says any order made under rules from which an appeal is expressly allowed by rules.
Yes.
So where it is expressly allowed?
Expressly.
Which expressly means something we do not have to, you see, like to find out something, we do not have to make an inquiry, it is there. A bare reading of the law would show it. Just tell us where it is provided that in an injunction matter, second appeal is maintained.
That was the only question, Lordship. Last occasion.
We do not know, Mr. Khan, whether the court's question is correct. No, but then we want to be enlightened, get enlightened. Probably do not know. Even if we find that like this second appeal is maintainable in an injunction matter, then this also has to be on the question of law, substantial question of law.
Lordship, I'll try to enhance the light. Court wants to be enlightened. Lordship will generally kind. First of all, there are two very limited answers that I want to just hurriedly give. Lordship, my friend is relying very heavily on 104 clause 1. Lordship will kindly come to 104 clause 2.
Yes.
If Lordship will go.
Yes.
The non-obstantive clause is no appeal shall lie from order.
Any order passed in appeal under this section.
Order of district deputy commissioner was an appeal by them from a
no passed under this section. So this section means like where appeal has been preferred by invoking 104.
Technically, Lordship. So what I mean to say is we have to read in conjunction, but I is clearly Basel. And the second thing, Lordship, I will agree and concur with the Lordship so far 227 is concerned, that finding of facts.
Finding that is what this is.
And
so
then
that is what at the basic, at the very starting, this court has indicated already that until and unless there is a gross error.
And then Lordship 115, Lordship also asked me why not 115. Lordship, kindly come to 115 clause 2 again.
Yes.
The High Court shall not, under this section, vary or reverse any decree or order. We are concerned with order, against which an appeal lies either to the High Court or to any other court. So the relevant issue is under 104, whether any appeal lies to the High Court.
That is what the revision will not be maintainable.
Absolutely, Lordship.
But then when that is when 115 is invoked.
Actually, but there is
but
no
220 is something, you see, 227 you cannot equate it with any statutory
totally
provision.
totally different.
It's
Totally. It's in own ground.
Because this is a constitutional.
And Lordship, we are very grateful that Lordship has read out the relevant part only on appreciation of fact, only on pure illegality. Court may shut me out. I have to show that it had exceeded jurisdiction or refused to exceed jurisdiction only on perversity of fact.
You see, like there has to be a gross illegality.
Gross illegality. Perversity of fact has to be written.
Gross illegality is something, you see, like illegality you may term. Say like there is a certain provision of law. The court doesn't take into consideration that provision of law.
Yes.
Passes wrong order.
Exactly.
This is a mere error of law.
Absolutely.
This will not give you scope to come
under 227.
But then, if there is an act exists.
Exactly.
And that act is not even looked into.
Correct.
This may result in gross error.
Absolutely.
We do not know the simplest way of trying to, you see, understand
Possible,
and they, like share it with you. But that is what is going.
And Himachal Pradesh.
So here, if you come with a case and you say that this appellate court has failed because of this and all those minor points,
correct.
Definitely 227 will not.
Will not be. Court won't appreciating now. The situation is whether court will appreciate the evidence and the judgment on merit, and then come 227 is not maintainable, or there is another statutory provision. 104 clearly is not applicable, Lordship. Now 105 also clearly says, 115 also clearly says bar. We have now, as rightly Lordship says, Himachal Pradesh does not bar maintainability. We are grateful, Lordship. So what it says is this:
is not decided on the issue.
No, yes.
That second appeal is maintainable, and that view of the matter 227 will not.
Absolutely correct.
It
doesn't say that. Had that been the case, Lordship, I would have withdrawn it, Lordship. I would have not argued.
Speaks about the scope and ambit of 227. So with that, there is
no,
no
it doesn't. It doesn't.
There is no dispute.
I would have withdrawn it, Lordship. I would have made an application.
Only if there is a perversity, definitely will.
Yes.
If not,
so the moment we harp on the perversity part, Lordship, then the issue is this: we have to touch the merit. No, and then court, after touching the merit, court will decide whether it should go or not.
Yes, Mr. Nandi.
My lord, if this of the same Himachal Pradesh judgment, para number 22 may kindly be perused. And in the entire this revision petition that they have filed, there is not a single word used that the order is perverse. Kindly peruse the memo of appeal.
That is okay. That is okay. But then we have to go to.
Now here, kindly this para 22
Yes.
is specifically mentioned.
What does it say?
Having perused the findings returned by the learned district judge while passing the impugned judgment vis-a-vis the materials available on record, this court finds it difficult to agree with the learned senior counsel representing the petitioner's plaintiff that the impugned judgment is not based upon material evidence available on record as such. Otherwise, otherwise also there appears to be no justification for this court to exercise supervisory
Yes,
power.
See, this petition was not rejected on the ground of maintainability. It is because the court refused to exercise jurisdiction, invoke its jurisdiction, saying that the basis on which the 227 application was filed, you see, this court didn't feel this thing, that 227, because there is no sign of perversity. That is what.
That is,
See, Mr. Nandi, two aspects. One is that there exists evidence, the court, trial court, or the court below, while deciding, failed to appreciate it properly. Now, you cannot go to superior court and say that the order suffers from perversity. Perversity is something when a finding is recorded without existence of any materials.
my lord, my lord.
So
now,
that is
now on this point, on this very, the lordship has very pertinently picked up this question, that where the perversity is to be, where is the wrong that has been, how it is perverse, the judgment. Now there, if the lordship kindly peruse the memo of appeal or the impugned order, they came up with an suit.
Are you trying to equate the grounds raised in the memo of appeal,
my lord,
that with that of a pleadings meant in CPC?
My lord,
See, that what matters is that what ground is raised at the stage of hearing.
that what is the grounds before your lordship, that is to be looked into.
See, exactly. So, do you want to say that just because, like, assuming what you say you are correct, just because there exists no ground in the memo of appeal whereby the plea of perversity has been raised, would it mean that senior counsels divert from arguing or raising the plea while he argues?
My lord,
Will there be something like the strict principle of CPC, the law of pleading apply? That something is not pleaded in the plaint cannot be raised.
my lord,
Now, if you see, you are making the thing, widening the thing. This court has a very, you see, like inquisitive mind. Would like to know many things from you,
definitely.
especially from the learned member of the law.
I deeply
So then you have
thankful
to say that
I am before this learned court.
that this argument has to be restricted within the grounds which is raised in the memo of appeal. Give us some judgment on that. Then we will definitely accept it. Because
Judgment,
these are
judgment on the points that
the argument
has
has
been
to
raised
be,
in
has
the
to confine within the written grounds raised in the memo of appeal.
yes.
If there at all exists something, this court has no knowledge of that. Anyway, see what do you want? You say like you want it to be
As lordship has
See, without-
decided to
until and unless you give us something very specific, very certain, we cannot reject this application at this stage, saying that it is not maintainable in view of availability of alternative.
then my lord, my one prayer is that let both the matters be taken up for hearing.
Which matter? Both means
Whether this CRP that has been filed is maintainable, and at the same time,
then we'll keep that issue of maintainability. Let it be adjudicated.
absolutely, my lord, absolutely, my lord, not only on maintainability, as maintainability along with the merit, let it be heard.
Definitely, that will be there.
Yes. both the matters I would like to place before the Lordship that whether on the basis that they have their pleaded case, their pleadings, whether there is any illegality has been committed by the learned lower appellate.
No, that is always there. You see, these are all these things
So
are
both
open.
these points,
These
on both
all
these
remains
points,
open to
both
the
on the maintainability of this
Definitely
CRP
that will
as
be
well
there.
as on the facts that they have raised, the grounds they have taken.
Please, next time when you come with some citations, please come with proper citations. These are very tough to rely upon.
Okay.
Because nowadays there exist many websites.
There's Lordship
What is genuine and what is not genuine, you do not know.
no, that is
probably recently you will find even the Supreme Court has probably come down heavily
on a district judge
Yeah.
court which
Who
has
takes
relied
reliance
on
on some
a,
non-existent
on a judgment which was non-existent.
that is
We see,
I
we have
am
to be
really
very much
surprised
careful.
to
because we take into consideration what is supplied by the learned counsel.
Definitely.
Today this court may pass some order relying on this, and tomorrow you may find it out this is not non-existent.
Non-existent.
that is the Lordship's. I will try to bring the solid things so that it is acceptable to this learned
Yes.
court.
Please make a list of
To
cases
honorable
and
court.
supply it advance to the other side so that there remains no hurdle.
Okay.
Mr. Khan also can go through all those things.
And on the next date, my lord, both the matters, both
That
on
will be-
law
that
points
we'll
as
say
well
it.
as on facts.
We'll say that your
will be
question of maintainability will be kept up.
Yes.
Absolutely.
Yes. Our learned counsel is paying with the parties.
Please give your number so that I can call you.
After arguing for subneth, it is agreed by the parties that the matter may be taken up for final hearing. Stop. As paid for by the parties, list this matter. When shall we list it for?
My lord, in the month of May, because otherwise I am totally packed up. Very difficult.
No difficulty over you, Mr. 4 weeks. List this matter after 4 weeks. Stop. The question of maintainability of the application of this petition is kept up.
You know, so the interim order was passed earlier.
The next question, the interim order passed earlier shall continue till the matter.
My lord, let it be both on the law.
That is open. Once we say final hearing, that is open. You do not have to specifically say that.
Okay. Deeply obliged.
And once we say the question of maintainability is kept open, that means you can raise it. Otherwise, normal assumption is that once a matter, a revision is listed for hearing, it crosses the hurdle of admissibility. But then for him that will remain.
Yes.
All right.